The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about general contractor agreements in construction. We're going to go over some of the most important clauses in those agreements and some things that you should be aware of with respect to each of those clauses. Let's start with the scope of work clause. The scope of work clause lays out exactly what the contractor is agreeing to do, what work they're agreeing to perform. The key to the scope of work clause is making sure it's not ambiguous at all. We want to be crystal clear on what the contractor is agreeing to do for the price that they're being paid. This is especially important in lump sum contracts where there's a flat fee that the contractor's charging for the work, because if the scope of work isn't clear about what the contractor is supposed to do, there can be a dispute between the owner and the contractor about what the contractor agreed to. We're paying you this flat fee. All of this work is supposed to be included in that fee, and the contractor says, no, it's not. If the contract is ambiguous about what work is supposed to be included, then that can cause a dispute, which can cause expensive litigation. So the best thing we can do is make sure that it's crystal clear what the contractor is supposed to do in the scope of work clause. The next clause you should be aware of is the contract price. We're going to go over real quick the different types of pricing that are common in general contractor agreements. One we talked about already, lump sum. That's pretty simple. The contractor is agreeing to do work at a flat price. That gives certainty to both sides, but it may put one side or another at risk of the work exceeding or being under the fair price that's being charged for that lump sum. Another way to do fees is similar. It's called unit pricing. It's flat fees for various components of the work. So the work is broken up into various stages or components, and a fee is given for each unit that the contractor is going to do. This makes sense if there's going to be projects in multiple locations, and we want to lock down a flat fee for each piece of work, and the locations may require different types of work that are repeatable, and we can have certainty for the owner as to how much things are going to cost. If this location requires, these 5 different types of work, he can just plug in the unit pricing to come up with what the total fee is going to be for each type of work. Cost of work plus contractor's fee. So basically, this is the contractor charges the owner for the contractor's overhead, plus on top of that a fee, and this can either be a flat fee or a percentage of the overhead. So oftentimes the contractor will get 10% profit, and the 10% is calculated based on whatever the overhead for the project is. So the more the overhead is, the more profit the contractor will get. Finally, the last way to do this is time and material. So the contractor will charge an hourly rate for his or her time and charge any overhead onto the owner. So the owner knows exactly what they're paying for the contractor's time, and whatever the overhead, the materials, labor are, that also gets billed to the owner. So let's next talk about the time of completion for the project. That's another important clause. This is really, again, one of the most important clauses in the contract and one of the most likely sources of litigation. Like the scope of work clause, we want to be crystal clear about deadlines to complete the work, and what happens if the contractor doesn't complete the work. There should be some sort of damages associated with that, or a clear, at least from the owner's perspective, a clear penalty that the contractor is going to pay if they don't complete the work on time. Aside from the scope of work clause in determining what's actually included in the work, the most likely source of litigation is a contractor being delayed in completing the work, and the owner having to basically sue to recover damages. If it's a commercial property, it could be the business didn't get started until 6 months after it was supposed to, so we lost all these profits. It kind of helps both sides to have certainty as to what the damages are going to be if there's a delay, and we call that liquidated damages. So we like to see if this is the deadline for each day or month or week past the deadline, whatever the parties want to say, it's going to be X amount of dollars that the contractor has to pay the owner. Sometimes the contractor gets a bonus for early completion as well. Let's talk about some key concepts here in the time to complete clause. There's a distinction between substantial completion and final completion of the project. Substantial completion is basically when the project is habitable or useful for its intended purpose, but there might be some minor things that still need to be finished up. These are called punch list items. Usually after substantial completion, the owner and the architect and the contractor will walk through the property, and the owner will point out things that need to be corrected or things that need to be finished. This is called the punch list, and when the punch list is completed, that's when final completion happens. Often the owner will retain something called a retainage, which is a certain percentage of any of the invoices that the contractor sends gets retained by the owner and isn't paid until final completion. This encourages the contractor to finish up the project on time. Often in these contracts, there will be milestone dates for measurable portions of the work so that the owner can be sure that the contractor is staying on track to finish on time. So you'll basically have milestone dates, and the contractor will, if the contractor is delayed in completing the milestone, there might be liquidated damages for that milestone. But at the very least, if the milestones are being hit, the owner knows that the contractor is on track to finish the project on time. Some other clauses that you want to nail down in contractor agreements is being explicit about how payments are going to work. So, we talked about the contract price, but sometimes there's ongoing monthly invoices. How often are invoices going to be sent, and how long does the owner have to pay those invoices once he or she receives it from the contractor? Finally, let's talk about change orders. Change orders happen when there's something unexpected that comes up in the project. So sometimes the owner wants to change part of the work. Sometimes the contractor says, there's conditions on the ground that are different than we expected. It's going to cost a little bit more to do so. And the process for that is the contractor to submit a change order requesting either more time or a larger contract price in order to accommodate the changed conditions. And then the owner will either approve or deny the change order. If the owner approves the change order, the contract price or the duration of the contract is amended. If the owner does not agree with the change order, then there needs to be some sort of dispute resolution system in the contract to figure out how things are going to work if the owner and the contractor can agree. So that's what you really need to know about contractor agreements, general contractor agreements. A lot of those same clauses apply to subcontractor agreements as well. Thank you so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation. Thanks for watching.